First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon and welcome to this virtual session of the First District Court of Appeal. We have two cases on the docket today. Both have been consolidated for all purposes, including oral argument today. Ernie Morris Enterprises, Inc. versus Contracts Furnishings and Greg S. K. versus Contracts Furnishing. Counsel for appellants, cross appellees, I understand you are reserving 20 minutes for your argument and 10 minutes for rebuttal. And counsel for appellees, I understand 25 minutes for your rebuttal and argument and 5 for sir rebuttal. Is this correct?
That's correct, Your Honor.
Okay.
Correct, Your Honor.
Thank you. I'll ask counsel to allocate the time accordingly among the parties appearing. And with that, appellants, you may proceed.
Good afternoon, Your Honors. May it please the court. I'm Steve Brannick of Brannick, Humphreys and Berman, representing Ernie Morris. I'll be kicking off this afternoon. As Your Honors know, we have spent our brief focusing on the damages issues, and I'd like to focus my argument today on what I think was the most serious and impactful of the errors that were committed below relating to damages, and that was the multiplier theory that turned what was at most $130,000 in damages into $730,000 in damages. Their theory went something like this. About a year after the event of this lawsuit, Ernie Morris got an investor who invested Meteor and Contract attracted an investor who put in 90% of the money for the corporation. This investment was based on they testified that this investment was based on an EBIT multiplier of 9 times earnings. Since they say they separate.
Mr. Brannick,
Yes.
you're arguing that because that was on the order of special damages and it wasn't pled, that it shouldn't have been allowed, correct?
That's correct.
Okay, so I'm trying to find where in the record that I guess Mr. McCormick had that part of the case, maybe, or anybody on behalf of Ernie Morris Enterprise made that specific objection below.
Well, the argument takes place at the transcript of pages, I believe, 92 to 105. I'm not sure if the word special damages were used in that argument. Clearly, the argument on our side was that we were absolutely surprised by this testimony, and that argument was raised both at the time of the argument and in the post-trial motions. So
you're saying that and I saw the argument complaining about the surprise. So it is your position that raising that surprise is the same thing as saying under the rules of civil procedure it had to be pled specifically, correct?
Very similar, Your Honor, because the cases that talk about why special damages have to be pled talk about it in terms of the surprise and the need to allow opposing counsel to be on notice of the type of damages that are going to be brought. I specifically can't recall whether the word special damages were mentioned in that part of the argument. Mr. Taylor, who's going to follow after me, can correct me if I'm wrong. But even if it wasn't, clearly we focused on the surprise, and there is no doubt about the fact of the surprise here. Putting aside the special damages pleading issue, the complaint says absolutely nothing about this sort of damages.
I could find in the record where Mr. Taylor raised the issue of special damages have to be specifically pled, and he raised that and he argued it, but I couldn't find anything on behalf of Ernie Morris Enterprise. It looked like during that time Mr. Taylor made what looked to be a proper objection, and Judge Brasington said, well, I'm not going to rule on that now. I'm going to let it come in, and then I'm going to rule on it later, and never really did.
Well, my recollection of the way that 15 pages or so of argument went down, that Mr. Taylor took the lead in arguing that those points on this particular issue. Just as oftentimes during the trial, there was a bit of a tag team going back and forth between Mr. Taylor and Mr. McCormick, because we were both essentially arguing many of the same issues on the same side. So I think that certainly the fact that Mr. Mr. Taylor mentioned the argument in the context of arguing this issue really on behalf of both parties. I don't think there's any question that the issue of special damages is then before the court as a pleadings matter. So,
Well, can we make the general assumption that, when you have co-defendants, that the objections of one co-defendant are automatically adopted by the other one, or is there some obligation on the lawyer to say so?
I would say that the best practice is to adopt, but I would say that in the rough and tumble of most trials, when there are a number of attorneys representing parties that are aligned on the same side, that often doesn't happen. But I mean, the most important thing for the purposes of error preservation is that the issue be presented to the trial judge, so the trial judge has a chance to react to it. The trial judge had that chance to react to it here. It wasn't a surprise to the trial judge. It's not a surprise to the parties, and so I think it's properly before the court. And it's just one of a number of reasons why we think the edicta multiplier theory was defective. So one, it was never pled as special damages, and the cases say that if you don't plead it as special damages, you can't raise it even if there is no surprise. But beyond that, we have the problem of surprise here. As I
So what about the issue where she said she was going to reserve ruling until later? She was going to allow the testimony to come in, and then near the end of the trial, she was going to make that decision and how the jury was charged. And she never got back to the issue. And, usually it's up to counsel to, when judges, leave things hanging, it's up to counsel to bring it back up to the judge. So it's not left.
Well, my recollection, Your Honor, is that when we got to the specific part of Mr. Latham's testimony, which is in the transcript, I think at pages 120 to 123, counsel stood up and objected on the basis of the same grounds that were raised in the beginning. And the judge said, I've ruled on that, and allowed the testimony to come in. So I think at that point in time, the damage was done. It was raised during trial. It was raised when the testimony was offered. It was raised in the post-trial motions. And of course, we're raising it here today. So turning to the issue of surprise, as I said, it wasn't in the complaint. It's not in the pretrial statement. The president of the company was deposed, Mr. Latham, and he was specifically asked about the damages at his deposition. He said our damages are $80,000. He was asked what that represented, and he said that was the difference in the bid. We had to discount our bid by $80,000. That's bucket one of the damages, which we've talked about in the brief. And then he was asked, is there anything else? And he said, yeah, we also had some time and effort that we put into this. We had some litigation expense, and that was the $50,000 that was in bucket two. He doesn't say a single thing about the sale of the company. He doesn't say a single thing about this edicta multiplier. And so it simply wasn't raised at all. You look at the exhibit list of the parties, there's not a single exhibit there's no document in this record that talks about this edicta multiplier. You would normally expect, if you were going to have a significant valuation issue like this, $1 million valuation issue, that there would be an expert witness. There was no expert witness here. All we have is Mr. Latham's testimony, followed by the CFO's testimony, just a few pages each. So clearly this issue was not raised. Clearly.
So if we were to find that some portions of the damages that were awarded shouldn't have been awarded, or shouldn't have been even presented to the jury, like this issue that you're raising first here, the edicta multiplier issue. I have the verdict here, and the verdict says total damages to the plaintiffs $730,188.57, and it says that against both defendants. So there was a lot of argument below, and then the briefs they're talking about the buckets. But how do we know what that number represents? And if we have to disallow some of the damages, how do we go about pulling that out?
Well, the jury obviously could only rule on the evidence that was presented to them. And the evidence is very clear here. It was presented all the way through this case in three buckets. Bucket one was $80,000. Bucket two was $50,000. Bucket three was the $1 million for the edicta multiplier. The only way you can get from $130,000, which was the total of buckets one and two, to the $730,000 verdict that the jury awarded is through bucket 3. That is all the evidence that this jury was presented.
What do you do, Mr. Brannick, though? We're missing 2/3 of the transcript, or we don't have a transcript for 2/3 of the first day of trial. We're missing any colloquy related to jury selection. We're missing the oral arguments, and we're missing maybe the key witness in this case, his testimony up until 3:08 on the first day. As I understand our obligation under the statutory harmless error analysis, which, as you know, is 59041, we are to examine the entire record. We don't even have the entire record of the transcript. So what would you have us to do with that if this is all about a failure to present evidence?
I've got two kind of overall responses to that, Your Honor. First, as to our arguments on bucket 1 and bucket 2 and bucket 3, we're making a purely legal argument. You don't need a word of the transcript in order to rule for us by saying these were special damages and they weren't pled. And on bucket 2, by saying that attorney's fees shouldn't have been awarded by the jury here. They were a matter for the court. And of course, the court denied attorney's fees. So that's the first of my response to Your Honor, which is that these were legal issues. The second one is that this missing transcript issue is seriously overblown. And I really commend to Your Honors to just take a look at the first 39 pages of the transcript we have. The transcript that starts at 3:08. We missed voir dire. We're not making any argument about voir dire. We missed the opening arguments. We're not making any arguments about not making any arguments about the openings. So we start in the middle of the testimony. I shouldn't say the middle, almost at the very beginning of the testimony of Mr. Latham, the CFO. And we know that it's almost the beginning of the testimony because of what he had to say. First, at page 17, they say, okay, let's drill down to the subject matter of this lawsuit. So the first time that he even talks about the lawsuit, we've got the court reporter there and he's being transcribed. Then they say, okay, now let's talk.
Mr. Brannick, how do we know that? I mean, how do we know that he didn't say something else before that? I appreciate the logic. It is logical, but there is a presumption that this record comes to us with, as I know you know, a presumption of correctness in this jury's verdict and the trial court ruling. So you're asking us to apply logic to something we don't have. So I'm just trying to appreciate how we do that.
Well, as many courts have said, you don't check your common sense at the door. So first, I just said, let's drill down to the subject matter of the lawsuit. That would indicate that's the first time he's talking about the lawsuit. Then on page 35, they say, now who or what is Ernie Morris Enterprises? You would certainly, it's certainly common sense that if they're asking about my client, Ernie Morris, on page 35 of the transcript, that we're just now getting started. And then even beyond that, page 39, now can you explain who Greg Cave is? Greg Cave, of course, is the gentleman that's at the center of this controversy. He was the employee that went from Meteor to Ernie Morris Enterprises. So clearly we are into the absolute beginning of this testimony when we're still introducing the parties. And then we have the rest of the 5 days of the transcript. And of course, we had everything that led up to the trial. All of that is in the record. And there was nothing in the rest of that 5 days of the transcript that would lend any credence to the fact that there was anything of significance that happened in that first few minutes that was missed when the court reporter didn't get there on time. So I think that this transcript issue is seriously overblown. Clearly, we have an obligation to present a transcript, but we have an obligation to present an adequate transcript, a transcript that is adequate to allow this court to rule on the issues. And I submit that it's absolutely clear from looking at where that transcript starts and looking at the rest of the transcripts of the 5-day trial that this court has exactly what it needs to rule that those damages were improper. So turning back to the question by, I believe it was you, Judge Roberts, about how do we know what the jury awarded, the only way that the jury could have gotten to the $730,000 is by bucket 3. Bucket 3 was the only evidence that was given to them. Now they're going to come back up here in their time and they're going to say, well, wait a second, we've got this Heil method. And we certainly talked about this Heil method, and maybe the jury was awarding damages based on that Heil method. I would commend to your honors, look at every transcript site that is given by the other side in their brief on this Heil method. They talk about it page 35 and 36 and page 3 of their briefs. You can read every one of those transcript sites. It'll take you 5 minutes and you'll see that this Heil method was barely talked about at all. It was talked about in gross generalities. There was no value placed on it. There was no discussion about why the Heil method would give extra value to Ernie Morris Enterprises and what the amount of that value would be. And certainly there was no attempt to quantify anything relating to the Heil method. Every page relating to damages you can read in probably 2 minutes. It's page 105, 120 to 23, 492 to 502, and 973 to 974. You'll see nothing in there beyond the 3 buckets. You'll see nothing, no evidence of any kind that would support any award of damages above buckets 1 and 2. So for those reasons, we think it's absolutely clear that the jury bought this addict to damage theory. They reduced it in part, but they still awarded at least $500,000 in damages.
Well, counsel, why wasn't that proper? I mean, Chapter 688's damages provision is a little unique and different than other damage provisions you see in the Florida statutes in that, you know, how do you measure actual loss? And in the statute, it talks about unjust enrichment by the misappropriation. And it also says very clearly in lieu of damages, damages may be measured by a liability for reasonable royalty. So it seems that the legislature's given courts a great deal of latitude in determining what actual damages are in this context. So why is it that the damages that were asserted in bucket 3 are outside that actual loss category and needed to be pleaded in a special damages pleading?
Yeah, but there still has to be evidence supporting that loss. And so how would you generally prove that loss? You would prove that as a result of this information getting out in public, my business is now hampered, and here is how it's been hampered economically. You probably would put an expert witness on who would testify about that. You would quantify exactly what the value of that secret was. You would quantify what the value of that secret was in the hands of the other side. You would quantify what that value was going forward. You could do that, but that was not done here. None of that evidence is in this record. The 10 or 15 pages worth of damages testimony that I've given to your honors, if you take a look at it, was everything there was on damages. So certainly they could have tried to prove that. They just didn't succeed in this case, not by a long way. So clearly you have to have evidence to support that sort of damages, and there was just no evidence of any damages resulting from the so-called Heil method and its impact going forward. So I see I'm intruding into my rebuttal time. So if I may, I'd like to reserve the rest of my time for rebuttal.
Yes, thank you.
Good afternoon, Cliff Taylor here from the Hogan Law Firm. Opposing counsel, Mr. Brannick, may it please the court. First, Justice Roberts, to address your concern about Mr. McCormick, he did raise the objection to special damages on page 496, lines 8 through 10. Following that objection, the court said it had ruled on that matter. I don't recall when she did, but she made it clear that she had at that point in time. As far as the key witness being missing, Mr. Childers in the trial, even at some point with Mr. Lathan's testimony, referred to him as not really that qualified to give us any information regarding the finances of the company. That would come later in the trial with the CFO, Mr. Rollins, and that's what happened. Mr. Lathan talked about some very general damages, but not the EBITDA theory itself. So that came later, and the CFO was the most qualified person from the defendant to do that. But let's talk about what that was too. It's a lot of hearsay that came in from the CFO regarding someone else that an investor talked about how That person evaluated the company. There is no opportunity for us to cross-examine that person. It was all the CFO relaying what was told to him on how that evaluation occurred. As to damages itself, this is a design to build project. It's a public project in Horry County, South Carolina. A lot like the building that the First DCA is in, the design to build builder has the opportunity to hire, fire, reduce scope of services, and elect competing bidders, which is what they did. The evidence shows that there was over 500 pages of CAD drawings and Reddit drawings that were supplied from the architect and from Metcom, the design builder, to both Mr. Cave as well as a independent individual, Vanessa Estep, who did a lot of the design work. There is no—
Mr. Taylor, if I could
Yes.
interrupt you for just a moment, and if I could alert the clerk that the clock is incorrect, and I think it was restarted for Mr. Taylor's argument. And as I recall, it was around 12 minutes. We could give him 13 that would be remaining for the appellant's cross appellees. So if you could correct that before we proceed. Okay. All right, Mr. Taylor, you may proceed.
Well, we have a design to build builder that knows that the plaintiff here, or the appellee, is above the budget set by the Horry County school system. It's a public document. It's out in the public for everyone to know. To be competitive, you've got to have your bid within that scope. They were outside of it. The architect and the builder invited Mr. Cave and Ernie Morris to submit a bid using even the documents that they received from contracts to get that bid, knowing full well they would be used. And that's what happened. As a result, they were still awarded the contract. There was also some confusing testimony about the $40,000 reduction from one of the vendors of contracts. Ms. Vero testified that there was a full $80,000 discount. Mr. Zawinski, who was on the team, said that identified Ms. Vero as being the person behind the scenes, person coordinating with everything, pricing with manufacturers, conversation with designers about changes in furniture scheduling, etc. So this person was well-versed in doing that. Now, Mr. Zawinski said that I didn't ask for that reduction. I was only told that it was a $40,000 reduction. Mr. Kinney, who supposedly asked for that reduction, did not testify during the trial. He was placed on the witness list after the deadline for that and wasn't allowed to testify. Yes.
Your argument seems to be going down a path of showing us that there was various bits of testimony and there was other bits of testimony and arguing which the jury should have believed, which I really don't think that that's where we are right now.
Perhaps not. I'm just trying to show that, we believe that there wasn't, we believe the Abita theory actually inflamed the jury to the point that it just didn't make any sense. And in fact, the verdict of 700 and some thousand appears to be some sort of compromise verdict that the jurors reached, because there was nothing in the evidence that would even support that. I'm going to reserve the rest of my time and go from there. Thank you.
Thank you, counsel. If we can set the clock to 25 minutes, 30 minutes, please, for the appellees cross appellants, and counsel, you may proceed with your argument.
Good afternoon. May it please the court. My name is William Palmer with Florida Appeals, and together with Mr. Childers, we represent contracts and meteor education in this proceeding. I'm going to address the first issue we raised in our answer brief, which is that the lack of a complete trial transcript or a statement of proceedings as to the missing portions dictates affirmance in this case. As you know, as already has been mentioned, 2/3 of the first day of the trial was not transcribed. There was no effort made to provide a statement of proceedings, which is allowed by the rules of appellate procedure. And as such, the only errors that can result in a reversal are errors that are clear on the face of the judgment. Not only are the errors raised by the other side not those kinds of errors, but they don't even argue that they are, by and large. The initial briefs of both parties didn't even mention that there was an incomplete transcript. We raised it in the answer brief, and then they responded. And when they responded, even then their argument wasn't, let's just look at errors on the face of the record. It was things like, well, in Mr. Cave's initial brief, he argued the court reporter was able to transcribe significant testimony. The court reporter was able to capture the most critical parts of the testimony. The most vital portions of the trial became part of the appellate record. And in fact, at page 2 of his reply brief, he specifically states that not all of Latham's testimony regarding damages is available in the appellate record. And then he goes on to say, but trial counsel summed it up on day 2. So I think this
Mr.
points
Palmer?
out one of the reasons why, A, without a complete transcript, you can't get to these issues that are
Palmer?
clearly. Yes, Your Honor.
You know, it seems like that you're very correct with regard to the issues that are based on whether there's substantial evidence in the record. But it seems to me that they're saying with regard to, they haven't, in the brief, they talked about the attorney's fees issues. And then issue 3 is this lost investment damages. Those seem to be more legal issues. So if there are things that are not in the transcript that would make those not tenable, point those out to me.
Well, I would point out that on those issues you've referenced, issue 2 and issue 3, that if you look at their arguments in the brief, they are not arguments that is strictly as a matter of law on the face of the pleading. So on issue 2, Morris's brief references the competent evidence at most suggests, that's at page 20. The damages claim lacked foundation at page 21. Meteor offered no evidence at page 22. And similarly, on every one of the 4 issues, phrases like there is no evidence, it did not prove, etc. The very last paper that was filed by Morris when they were asking for more time for oral argument asked for it because, quote, the case presents complicated, factually intensive issues and is subject to lengthy record and transcript, end quote. So they have consistently throughout their briefs, throughout their arguments, made arguments based upon competent substantial evidence, the overall record, not an argument that this on the face of the pleadings is reversible.
Mr. Palmer, but what of their argument that the third bucket of damages had to be pleaded as special damages, regardless of any failure of proof that there was a pleading deficiency?
Well, I would suggest, Your Honor, that without a complete transcript, this court really can't decide that issue. We don't know what occurred during that first day of trial that we have no record or substitute for the transcript of, as far as any concessions, any discussions, any stipulations, anything. And as such, that's not an argument that on the face of the judgment, this is legal error, which is what the standard is when you have an incomplete record.
Could the parties concede that a certain category of damages are not special damages?
I think they could concede either that it was or that it wasn't. They could concede that it had been adequately pled, or they were trying it by consent, or there was no surprise. There's any number of things that could be said, and that's why you need a complete transcript. And since even the appellants don't agree what occurred during the testimony on the first day, since Mr. Cave says that there was testimony from Latham about damages in the appellate record that was not transcribed, and Morris says no, there wasn't, that sort of points out exactly why you need to have a complete transcript in order to make that decision. In the reply brief of Morris, where they attempt to argue why to the extent Morris presents legal challenges, the transcript is irrelevant. They cite 4 authorities, none of which really are applicable to this case. They cite 3 cases, the Omana case, which was affirming a summary judgment, so that's not a case that involves transcripts. They cited the Dugan case where a motion to dismiss was granted, so the only issue there was the sufficiency of the pleadings in the complaint. And the Darling case was a death penalty case where there was some pretrial proceeding that wasn't transcribed. It didn't involve the existence of no trial transcript itself. And then they cite Padovano's book on appellate practice, but lots of sections of Padovano's book show why it's not applicable here. For example, he notes that if a party seeking review fails to make an adequate presentation of the facts in the statement of evidence, the appellate court may be unable to determine the existence of reversible error. In this event, the court would have no alternative but to affirm. And it quotes extensively from the Applegate case about why without the record, you can't decide the facts. And without that, you can't even determine whether the law was properly applied.
And thank you, counsel. I think we understand the legal principle and Applegate. So let's turn back to the statute if we can, moving beyond that argument. In terms of 688.004 and its use of the term actual loss as a portion of damages, what does that term mean, and why can or can it not include the special damage or the damages that were in bucket 3 in this case?
If I might, I'd like to defer to Mr. Childers on that since he's prepared to address that issue. I think I've completed my presentation on the incomplete transcript and would defer to Mr. Childers on all the additional arguments. Thank you.
Thank you, counsel. Mr. Childers, you may proceed.
May it please the court, and good afternoon, everyone. Your Honor, I'll just move right into answering that question, which seems logical. As you noted, the Florida Uniform Trade Secrets Act broadly defines damages. And I think the other thing that's really interesting about that act is in section 688.008, it actually specifically or explicitly says that the act's provisions displace all conflicting law related to civil remedies like damages. And as Your Honor noted, the Florida legislature's policy was to discourage trade secret misappropriation. So they made that definition of actual damages as broad as possible. And to your question, I think the case that we would look at is the Premier Lab Supply case. And in Premier Lab Supply, the 4th DCA provided a non-exclusive list that I think is helpful for us. In that case, the court said, quote, "In the present case, the trial court defined actual loss as loss of profits, lost customers, or lost market share to the owner of the trade secret by the misappropriation. We do not find any abuse of discretion in this definition." Further in the case, the 4th also included lost sales as a possible actual loss. So the categories of damages that Premier Lab Supply identified are very analogous to the types of damage that we're talking about here, that we're arguing about whether should have been considered actual damages. And the ordinary analysis of compensatory versus special damages relates to other civil law, which would be displaced by 688.008.
And so that would include the value of the firm. So that would include the value of the firm. So just hypothetically, you have a firm that has a business process, let's say Airbnb, and someone takes that process and they appropriate that process and they start their own business. The value of Airbnb has gone down by some measure. And so that's the type of argument that's being made here. So if you could respond to Mr. Brannick's argument that you didn't provide sufficient evidence to support that loss of valuation of the firm type of damage argument.
Sure. And let me just add one more point. the damages that you just described are what are commonly referred to as intangibles, right? The intangible value, the goodwill value of a company. And that's what a trade secret is. So a company like Coca-Cola that has a trade secret, the formula for its classic beverage, has greater value because that formula is a secret. And once that secret gets out, then the value of Coca-Cola, its stock price, similar to the Airbnb example that you just used, would fall inevitably. So what the statute, the act is trying to do is to preserve that value. So when it talks about the value of the misappropriated trade secret, that's exactly what it's referring to, is that intangible value inherent to the corporation.
And so if you could then also, you think, again, Mr. Brannick discussed the Heil method, but your argument on trade secret was not limited to the Heil method. Was it also include customer lists and communications with customers, or was there something else that perhaps I've missed in this very long transcript?
Sure. There was also evidence presented to the jury about the thousands of hours that were required to create the Horry County specification, which was a confidential trade secret. And to your point, there was also evidence presented about the theft of Meteor's customer list. In particular, there was a bit of dramatic testimony about a handwritten note that Ron Morris had made where he wrote customer list goodwill bonus right under the $115,000 that they gave to Greg Cave while he was still working at Meteor. So there were testimony about all those different trade secrets and the value. I think counsel referenced that there was insufficient evidence for the jury to have calculated some of those values, and that's where we get into the problems with the missing portion of the transcript. I think from my point of view, there are three critical things to note about the ambiguity over damages. First, there's no way to tell what numbers the jury included in the damages award that they made. And a lot of smart attorneys have been trying real hard for a while now to figure out how the jury arrived at that number, and we can't figure it out. I would direct you to Ernie Morris's cross-answer brief at the beginning, the first sentence of their argument section in their answer to our cross appeal. They say Meteor's not satisfied with its compensatory damages award, and quote, which may include its attorney's fees expended in the North Carolina action, end quote. May include, meaning might include. That is, nobody knows what's included in that number. Not all the damages evidence from the trial is in the record. And as Mr. Palmer indicated from that cite from Mr. Cave's reply brief, he says explicitly that not all of that damages evidence from Mr. Latham's transcribed testimony is in the record. Mr. Brannick identified Mr. Latham as one of the key witnesses on damages. And I agree, Mr. Latham is the key witness on Heil method damages, on the man hours, and on the value of his customer list. He also provided foundation for the special, what they're calling the special damages, the lost value damages. But Mr. Rollins, the CFO, who was a CPA/MBA, testified about all the evidence supporting those lost value damages. And, he testified at length about that for the jury, not only about the fact that they were damages to the organization, but exactly to 2 decimal places how those damages were calculated. And he testified about causation, that the damages would not have occurred had it not been for the misappropriation. So without...
Counsel, one more question on the special damages, general damages under the statute. Again, given that we're dealing with an intangible, the legislature's given a lot of latitude to trial courts to try to, consider different formula. Are you aware of any authority that has classified a particular valuation method as a category of special damages?
Your Honor, not specifically, no. But again, I would suggest that this is just a different way of calculating the value of those misappropriated trade secrets. And I would further say that there's a really strong reliance argument here because on the evening of the 4th day of trial, the parties held a charging conference. And the jury instruction that Meteor drafted for this kind of damages, which were called lost profits at that time, were objected to by Morris and Cave. And so Meteor agreed to use Morris and Cave's instruction, jury instruction number 13, as they drafted it. And that was titled lost value damages. And so that's where that term came from. That term came from the appellants. And they did not object to their jury instruction number 13. And the court relied on jury instruction 13 and read it to the jury. And when we made our closing arguments, we summarized our evidence consistent with the way that jury instruction number 13 was drafted, meeting the elements that were described in that jury instruction. And again, without any objection from the appellants at that time. So this is almost an invited error issue. The jury instruction drafting occurred long after any objections in the record were made about special damages and so forth. And so I would argue either that it was an invited error, and the X-Tech case, which I think we cited in our briefs, is the best example of that. And in that case, the court said, quote, defendants approved this instruction and cannot now request a new trial by suggesting this question is a matter of law rather than fact, which seems to be on all fours with our case. I would also suggest that by drafting jury instruction number 13 and then failing to object to it, that they waived any previous objection that they had to those damages. In any event, we relied on that when we put on our closing and asked the jury to rule in the way that they did. I would also say that the appellants could have asked for a special verdict form for damages, but they did not. Had they done that, then we would be able to see what damages were allocated to each of the different types of damage. However, they approved the verdict form with the general damages line for the jury, and so now we can't tell what's in those damages buckets. So that's what I would say to that, and I'll reserve the remainder for my argument on the cross appeal. Would Your Honor like me to start that now or have the reply on the initial argument first?
You may start that now if you would like.
So the record in this case reflects a tremendous amount of legal work that occurred over 4 years and 11 interlocutory appeals. So this court, using its inherent authority, can easily estimate the reality that fees in this case are equal to or even exceed the compensatory damages award. Why are the fees in this case so high? Well, the trial court told us why in its order awarding exemplary damages. Trial court said, quote, there is no doubt that the multiplicity of appeals combined with other litigation conduct by the defendants, the appellants, has drastically increased the cost, complexity, length, and difficulty of this otherwise straightforward case. The case was not close. So the trial court said it didn't just say they increased the cost, they drastically increased the cost. The appellants drastically increased the cost of this straightforward case that was not even close. Well, what kind of litigation conduct was the trial court talking about? Well, the order describes that conduct. Quote, the appellant's conduct during this litigation weighs in plaintiff's favor. During discovery, this court was required to enter substantial sanctions against each of the defendants for their obstructive conduct and found that the defendant's conduct was inequitable and did not evidence a good faith attempt to comply with their discovery obligations. So the reason the conduct was important is because it was inequitable and didn't evidence good faith. But why? Why did the trial court find that the case was not even close? Well, it said, quote, even Ernie Morris's counsel at the preliminary injunction hearing commented on the evidence already in the record unfavorable to his client, admitting that, quote, at first blush, it looks bad. Two trial judges, this court and Judge Parsons in North Carolina, found early in the case that the plaintiffs were likely to prevail on the merits. Plaintiffs did prevail, and after years of litigation, the jury found in their favor on every issue asked. And how about all those interlocutory appeals? How many of the 11 interlocutory appeals did the appellants prevail on? They prevailed on 0, none of them. In other words, the fees were so high because the appellants drastically increased the cost, complexity, length, and difficulty of an otherwise straightforward case. So, Your Honor, our argument is that from the face of the order awarding exemplary damages and denying fees, the trial court abused its discretion because the order is facially inconsistent. I've got 3 points on that. First, the trial court mainly relied on the compensatory award as its basis to deny attorney's fees, even though compensatory damages are awarded to put a party back in the same place it was before the original harm occurred. It doesn't account for litigation conduct. Attorney's fees are awarded for the damages that occur to a party after litigation commences in the form of attorney's fees and costs. The trial court's basis to deny fees undermines the deterrent effect of an award of attorney's fees under the Trade Secrets Act, which is clearly what was intended because that discretion to award fees is included in the exemplary damages paragraph. The second category is the Kanakaris accident argument, excuse me. Kanakaris is usually cited to support a trial court's broad discretion, but it does include, it sets out limits, and the limits described in that case apply here. Despite finding extraordinary facts related to the willfulness and misconduct of the appellants who had drastically increased the cost of litigation, and without finding any mitigating factors at all, the trial court failed to hew to prior decisions where similar facts led to significant exemplary damages awards and awards of attorney's fees. And the third argument, Your Honor, is that with regard to that litigation conduct, as a basic matter of equity, justice, and fairness, because the trial court found so specifically that the appellants had drastically increased the cost and complexity of the case, but also then denied fees without any substantial reasoning as to why, we would argue that would abuse the discretion. So I think the key issue is that the appellant's extraordinary level of willfulness makes this an extraordinary case, and the trial court failed to recognize that it had an extraordinary case before it when it denied fees. The trial court's denial of fees was based on 3 components. It's a very short line in the order. It says, because of the discovery sanctions that were awarded against the defendants, the compensatory damages award and the exemplary damages award, the trial court denied fees. Well, let's take those one by one. The discovery sanctions award was a sanction against the 2 defendants for 1 deposition and related production. So it was a pretty important deposition, and there were a lot of people there, and there was a lot of prep work on it, and there was related production that was not made, and the trial court awarded $16,000 against each defendant as a result. So that's a very small amount of the total that the trial court considered. The compensatory damages award, we all know what that number is. We don't know what went into it, but that's about 90% of the total of what the trial court considered in denying fees. The final amount, of course, is the exemplary damages award, which, as we pointed out in the brief, is a very small amount relative to the compensatory damages. So as I said, the compensatory damages are a different type, a different category. It's apples and oranges and shouldn't have been used as a rationale to deny fees. In Kanakaris, the court said that, quote, judges dealing with cases essentially alike should reach the same result. There's no case that anybody can find where a trial court made these kinds of findings about willfulness and wrongdoing and then subsequently denied fees. The cases that we do have where the courts limit or reverse exemplary damages and fees always turn on mitigating factors. But here, again, this is a really important point. The trial court found no mitigating factors in this case. So, Your Honor, we would ask that the court would affirm on the main judgment and reverse on the order awarding exemplary damages and denying fees, and instruct the court to hold an evidentiary hearing to determine reasonableness of fees. However, since the trial court explicitly based its denial of fees on the damages award, if the court were to reverse on any damages, then it should remand with instructions to award fees, because that would undermine the trial court's reasoning for denying fees in the first place, if that makes sense. And thank you. I'll reserve the remainder.
Thank you, counsel. Appellants, cross appellees, you may proceed with your argument.
Thank you, Your Honor. We may not know exactly why the jury reached the number that it did, but we do know exactly what the other side asked for, and we do know exactly what evidence they presented. Mr. Latham quantified the damages at the transcript at pages 120 to 123. His CFO, Mr. Rollins, quantified their damages at pages 492 to 502 of the transcript, and counsel summarized those damages for the jury in closing argument at pages 973 and 974. The only numbers that were given to the jury were $80,000 for bucket one, $50,000 for bucket two, and $1.1 million or so for bucket three. No other number was given to the jury. No value was placed upon any trade secret. No value was placed upon the Heil method. The only basis for the bucket three number was testimony that folks, when they invest in a company, often invest on a multiple of earnings. And here they said the proper EBITDA multiplier was something like 9.22 times earnings. That's the only testimony that the jury heard. That had nothing to do with any trade secret. That had nothing to do with any loss of value going forward. That was just plain and simple, taking a number, multiplying it by 9.22. Think about what that would mean. If that sort of damage, very simplistic damage theory, were approved by this court, every single plaintiff could say, who had a corporation, could say, all right, my damages in this case I proved are $140,000. Now, if I wanted to sell my company tomorrow, because of that loss of $140,000, my EBITDA multiplier value is now 9.22 times $140,000. So my damages are actually $1 million. Every single case could present this issue. And what I think is very interesting.
Mr. Brannick?
Yes.
But Mr. Brannick, isn't your argument undercut a bit by the special verdict form and the agreement to classify some of these damages as lost value? I mean, what do we make of that?
Well, the only lost value, there was not a word said in this case about lost value. No numbers, no quantification at all. The only evidence supporting lost value was this EBITDA multiplier a testimony that you just multiply earnings by 9.22. That has nothing to do with the trade secrets case. It's just a plain old.
Well, if that's the case, sir, then why do we have a jury instruction that says lost value in it? I mean, again, what is a reviewing court to do with that?
At that point in time, it's good to have big. Can you still hear me? We're having a big thunderstorm here.
We can.
Okay. At that point in time, the court had already ruled that this evidence was going to the jury. So all we did at that point in time was present a jury instruction that would help the jury make that calculation. That's not waiving anything. It's living with the reality of the court's rulings. And that jury instruction, basically all it says is that damages have to be proven with reasonable certainty. There's no magic about that. Obviously, we all know that that's the rule. And that's a big part of what we argued in our brief, is that these damages were not proven with reasonable certainty. It was just pure speculation. So we just don't think there is any support in the record. They certainly could have presented a lost value sort of case. They didn't do that. They presented an EBITDA multiplier case. And if your honors approve that, you're going to see that in a lot of cases, and a lot of plaintiffs are going to be multiplying their damages by 9.22. I don't think that is a good result for this case, and it's certainly not a sound result going forward under Florida law. So I want to touch a little bit on this transcript issue. I think I said a lot about it before, so I don't want to repeat myself, but I think it's absolutely clear that even if your honors were to disagree with us about the significance of what exactly was missing, The special damages issue, whether they pled that or not, obviously that's a pure legal issue. It's not in the pleadings. Your honors can rule on that. And it has nothing to do with the transcript. The surprise issue, that's all the run up pre-trial. That's all in the record. The transcript has nothing to do with that. The attorney's fee issue, bucket 2, that's a pure legal issue about whether the jury can award damages from the North Carolina injunction proceeding, has nothing to do with the transcript. So I don't want that to get lost in the shuffle of everything that we're talking about today. So let me talk a little bit about special damages. What exactly is special damages? It's just what the name implies, that special damages are something special you don't see in every ordinary case. And that's exactly what we have here. Their theory is that a year after this bidding went down, they sold the company. And as a result of selling the company, because their earnings were $130,000 less, using the EBITDA multiplier effort, that meant that the investment value went down by a million. That is special by any definition of the word. I think the Hardwood case is a good case to look at. Yes.
Doesn't it naturally follow that if a company loses a valuable trade secret, the value of the enterprise goes down?
Absolutely. And I'm not arguing about whether they could prove lost value to the company as a result of losing the trade secret. I'm arguing that they can't just say completely separate and apart from any proof of lost value from trade secrets, just say that by virtue of the fact that they sold their company a year later and folks used a 9.22 EBITDA multiplier in order to value their company, that is their damages. That's what's special about this case. The lost value of a trade secret, that's not special. I'm not arguing that. What I'm arguing is this EBITDA multiplier effort. That is special damages. You're not going to find any case in Florida that supports that method of valuation. If they wanted to try for it, God bless them, but that's why we have the rule on special damages. If they had pled that, clearly we would have been prepared with an expert at the trial to talk about why this EBITDA rule is nonsense. I mean, just think about it for a second. They say that they lost $130,000. And so you multiply that by 9.22, but they also ignore that they saved a bunch of money. They didn't have to pay Mr. Cave his bonus at the end of the year because of what happened. So that means their earnings went up, but there's no credit for that. I mean, it's just so completely speculative. And are we to think that an investor is going to come in and put in, $1 million down for a company based on nothing more than a simple multiplication of earnings without any consideration of profits, without any consideration of long-term prospects of success? That's completely and utterly speculative. So for all of those reasons, we think that bucket 3 was just simply improper. It shouldn't have been presented to the jury. It should have been pled. It wasn't pled. It should have been disclosed. It wasn't disclosed. It should have been supported by the evidence. It wasn't supported by the evidence. So for all of those reasons, we think that the damage award here was improper and should be reversed. The only thing I'll say on the cross appeal issue, because we've talked about this very thoroughly in our brief, was that the judge took into account everything Mr. Childers said in his argument. And the judge said, despite all of that, I'm exercising my discretion, and I believe that the defendants have been punished enough, and that I, the trial judge, do not think that an additional award of attorney's fees is appropriate. That's a purely discretionary ruling. We don't think it was an abuse of discretion. So for all those reasons, we think that the damages award should be reversed, and the cross appeal, the issues on the cross appeal should be affirmed. I'll reserve the rest of my time for Mr. Taylor if he has.
Yeah, what if we do grant, as far as some of the damages, we back some of the damages out? That totally undermines Judge Brasington's rationale for not awarding the fees. We would have to send it back for a hearing on that, right?
I think that's fair. I think if you come up with a different number, I do think the judge has to look at it holistically.
Okay.
Mr. Taylor?
Thank you.
Just briefly, I'd like to comment on the judge's discretion. And I'm not trying to discount the judge's findings of some misconduct that occurred during the trial. But if you look at what happened in North Carolina prior to the Florida litigation, and this came out in the Florida litigation, that the affidavit supporting the injunction enjoined Ernie Morris and Mr. Cave from a wide variety of customer lists that they admitted that they had no business relationship with. In addition to that, they even got an injunction against Mr. Cave's home school where his children went to school and his wife taught, where he had no contact with them. And they admitted they had no business relationship with this county school system. And as far as the customer list in this particular area of business, we're talking about companies that invest a lot of time and effort with public entities. It's not a secret customer list. These individuals, they post on their website how much money they're spent on particular projects, and all of this is out in the public. It's public record. So it's not a secret. So I don't know what the judge was using as far as her discretion, but some of it might have been what happened early in the trial with the admissions on the North Carolina case. And I'm not trying to condone any wrongful conduct by anyone. Thank you.
Thank you, counsel. Madam Clerk, if you would give the counsel for Appellee's cross appellants an additional 52 seconds on the clock, since we allowed appellants to exceed their time. We'll wait for a moment for the clock to be updated. Thank you. Mr. Palmer, Mr. Childers, you may proceed.
Thank you, Your Honor. First, let's talk about the EBITDA issue. EBITDA is a red herring. EBITDA was just the CPA MBA's explanation to the jury for how he calculated the lost value damages. It wasn't argued as some novel category of damages. EBITDA is an acronym that accountants use. It stands for earnings before
Excuse
interest.
me, I hesitate to interrupt, Your Honor, but this is not the cross appeal issue. This is going back to the main appeal here. I think this is improper.
Counsel, Mr. Childers, you may proceed. You are in your rebuttal time and you have 5 minutes remaining.
Thank you. Your Honor, the denial of fees was particularly egregious considering the trial court's findings about the kind of misappropriation that occurred here. And if you review the cases in the literature on misappropriation, you find a wide panoply of types of cases. There are cases where misappropriation is nearly accidental, where a party just had, for example, inquiry notice that the information was a trade secret. There are cases where there could have been honest misunderstandings about the scope of a contract permitting the use of a license and so forth. But we don't have that kind of a case here. This case is really an outlier. This case represents the worst kind of misappropriation that a court could possibly conceive of. I mean, I suppose you could always conceive of worse facts, but I would look in particular at paragraph 12 from the order awarding exemplary damages. And the court found in that paragraph, quote, "The misappropriation was not a one-time occurrence. Although the misappropriation led to damages relating to one major project, the defendants engaged in the conduct related to the misappropriation over a period of several months during 2016. Their conduct was an intentional, organized, well thought out plan, beginning in the summer of 2016 and extending through the period in November 2016 when Cave was secretly employed by both plaintiffs and Ernie Morris at the same time. Both defendants concealed that misappropriation. So, Your Honor, counsel expressed some concern previously in his argument on the main appeal that allowing the EBITDA style damages to stand would set some kind of a negative precedent. But imagine the negative precedent that it would set for future misappropriators who are considering entering into an intentional, organized, well thought out plan to steal someone else's trade secrets, and knowing that there was case law supporting the denial of fees on facts like these. I think that's the precedent that we're more concerned about setting, and the principles of equity and justice demand that the court affirm the underlying judgment and reverse on the issue of fees, and ask the trial court to set a hearing on reasonableness. Thank you, Your Honor. I'll stand on that.
Mr. Palmer, did you have anything further?
Nothing further, Your Honor.
Okay. Thank you, counsel. Thank you all for your arguments today. This court will stand adjourned. Thank you.
Thank you.